Welcome to our presentation on workplace considerations and compliance in light of COVID-19. Our presenter today is Anne Zerbe, who is the president of the York County Bar Association and also managing member of the York office of McNees Wallace Nurick. She's a leading attorney in the Labor Employment Practice Group, where she focuses on prevention of employment liability, defending against employment claims, and assisting clients with compliance issues concerning employment laws and governance. And counsels employers, practice groups, and healthcare providers on employment law compliance, risk management, and HIPAA compliance. And additionally, she serves as a special counsel for investigations and is a trusted resource to handle executive terminations and
much. For those of you who are trying to stay on top of things, we know that the laws have changed very quickly and are moving fast. We started off the pandemic with the federal law, the Families First Coronavirus Response Act. This applies to all employers with less than 500 employees. It was signed into law on March 18th. It took effect April 1st, and it sunsets on December 31st. And it's a pandemic response designed to give employees paid leave for COVID-related reasons. The first part of that is the Emergency Paid Sick Leave Act. That provides up to 80 hours for full-time employees. For part-timers, it's a 2-week equivalent of paid leave. For individuals who have COVID symptoms and are seeking a diagnosis, who are subject to a quarantine order, or are caring for someone with COVID, or the person is unable to work or telework due to COVID reasons, childcare or school closures. And the Emergency Family and Medical Leave Expansion Act provides up to 12 weeks of paid leave for individuals who are unable to work or telework because of childcare or school closures, all related to COVID-19. This also applies to nonprofit employers and public agencies, public employers, regardless of the number of employees for those public agencies. Private sector, it's got to be fewer than 500. Now, back at the beginning, there were some questions about, well, what if somebody had, what if we told someone to self-quarantine prior to April 1st? Are they entitled to emergency paid sick leave? No, they're not entitled to emergency paid sick leave if they took it before April 1st. Keep in mind, too, employers will get tax credits for the paid leave under this law, so you need to make sure that you are applying it correctly and that you retain appropriate documentation. In addition, if you laid people off because of closures or lack of work prior to April 1st or after April 1st, a layoff or lack of work does not qualify for the paid sick leave. Now, we talked about those covered reasons. Keep this in mind, because if you are currently operating, this law is in effect, and if you are returning to operations, your employees might need leave in June. They might need leave in August or September if schools don't reopen. So this isn't something that's just relevant now while at least York County is in the red closure zone. As we move through to yellow and green, and as things perhaps come back in the fall, keep in mind that if your employee hasn't used their emergency paid sick leave or their emergency FMLA leave, they may be eligible for it, and they need to be given that leave if they have a qualifying reason. Employers also need to continue their health insurance benefits during the paid leave, so whether it's paid sick leave or those 12 weeks of emergency paid family medical leave. In addition, maybe you saw that the DOL issued guidance on COBRA. COBRA is what employers issue if you have more than 20 employees or 20 or more employees, and that allows individuals to continue their health insurance benefits if they lose their benefits due to lack of work or layoff. Recently, guidance just came out that basically says there is no late period for COBRA premiums from, I think it's March 13th until 60 days after the end of the national emergency. So that means that if individuals are paying their premiums late, they're not going to be, their benefits shouldn't be canceled because they're making late payments. Now, under the paid sick leave, it's 100% except there is a cap. That 100% is for 3 reasons. They're subject to a state, local, or quarantine isolation order. And we've been suggesting that if the employer tells someone to quarantine because they may have been exposed, that employee should get the paid leave at 100%. And of course, you do have to document it properly so that the employer can get the tax credits. The other reason is that they've been advised by a healthcare provider to self-quarantine, or they are experiencing COVID-19 symptoms and they're seeking a diagnosis. They're going to the doctor to get testing. And those reasons are paid at a higher rate of up to $511 a day, $5,110 total. If an individual needs leave to care for someone who is subject to a quarantine order related to COVID, or their child they need to provide childcare because their school or daycare is closed, or their babysitter is unavailable, they are also entitled to paid leave, but it's at 2/3 the regular rate of pay. And that is capped at $200 a day, or up to $2,000 total for the first 2 weeks. Now, that third reason, the Department of Health and Human Services kind of punted that to the Department of Labor, and the Secretary of the Department of Labor hasn't explained what that substantially similar condition could be. So that we don't need to worry about right now, but it is a catch-all. If there's any other similar condition that the federal government feels would qualify, they might be eligible for paid sick leave. Now, keep in mind, once it's used, it's used. So employees can get up to 2 weeks of emergency paid sick leave for those reasons that we discussed. But if they need additional leave, or they need leave to care for their son or daughter because school's closed, daycare's not available, and as we get into the summer, summer camps, summer daycare is not available or closed due to COVID, those individuals can get up to 12 weeks of leave, and that is job protected, and you have to continue their health insurance. Now, the emergency FMLA leave is for full-time and part-time employees, just like the paid sick leave. However, in this case, the emergency FMLA leave is for those employees who have been employed for at least 30 calendar days. There are some exceptions. Employers with less than 50 employees may be able to take advantage of some exceptions. Those exceptions are when the paid leave would jeopardize the ongoing business viability of a small business. And they've given us additional guidance on the Department of Labor. They've issued some facts that say, all right, here are 3 ways that small employers with less than 50 employees may be able to say, we cannot provide this paid family medical leave because the expenses and obligations exceed our revenues and would cause us to stop operating. Or, look, that person has specialized skills and knowledge, and their absence would cause a substantial risk to our financial health. Or we don't have sufficient people who are available or willing or qualified to perform the services that that individual performed, and we need that for the business to operate. Now, for York County Bar Association members, for other members joining us out there from other counties, if you are a small employer, but you're a law firm, your practice has been almost entirely physically closed or significantly restricted, and everyone's working remotely to the extent possible. So for those employers who are operating remotely, I think it's going to be hard for you to try to demonstrate that you can take advantage of those exceptions because you're already working remotely. And keep in mind that if an employee can telework, they're not eligible for the paid leave. It has to be an inability to work or telework. Again, the emergency family medical leave, that is paid at 2/3 the regular rate of pay, up to a cap of $200 a day. Keep in mind those first 2 weeks, they may qualify for the emergency paid leave, and then it runs concurrently with the emergency family medical leave. It's capped at 12 weeks though, so you don't add it on. It is capped at 12 weeks. In addition, the emergency FMLA, it's a new reason for FMLA leave. It doesn't give more weeks. Many of our York County Bar Association members, and maybe many others of you out there, are not subject to FMLA, so this is kind of a new animal for you. If you are subject to FMLA, employees who've already used 12 weeks of leave under the FMLA, they are not entitled to emergency FMLA leave. They've maxed it out, they've exhausted it, so they're not entitled to that, but they can use emergency paid sick leave. In addition, additional guidance has come out. We know that employees may choose to add PTO on top of their emergency FMLA leave. They can't be required to use it on top of the emergency sick leave. Keep in mind, if you are allowing employees to supplement their pay with the PTO hours, paid time off hours that are available, you're not going to get tax relief credits for that. You're only going to get tax relief credits for those daily maximums for qualifying reasons, provided that you have appropriate documentation. And let me just go back one second. So documentation is required. If it's under the first two reasons for self-quarantine or seeking a diagnosis or local, state, or other quarantine order, the employee has to provide the employer with a written leave form. And in some cases where the employee is not available to physically do that, or they can't do it remotely, HR can fill it out while talking with the employee on the phone. You just need to make sure that you document the name of the healthcare provider who recommended or required quarantine. In cases where they're not available to work or telework because of childcare or school or babysitter, they need to state why they can't work or telework. And it has to be a reason such as, my husband was watching the children, daycare's closed, my husband was watching the children, he's been called back to work, we have no one available to watch the children. Or my babysitter's quarantined for COVID, no one available. So those are all reasons and documentation that will support the tax credits for the employer. The CARES Act, it established a number of other things, but what we also know is that it provided this pandemic unemployment assistance program. And just real quick, make sure you take the poll so that you can get your credit. So the PUA program expands eligibility. Typically, independent contractors, gig workers, self-employed, those individuals would not be eligible for unemployment compensation benefits. They are eligible because of COVID. In addition, the PUA program supplements our state unemployment compensation benefits. So employees who are getting unemployment through the state can get an additional $600 a week in benefits. It's retroactive back to April 4th, and it applies to all individuals who are otherwise entitled to receive UC benefits. That's an additional $600 a week. And it extends the benefits up to 26 weeks. However, employees cannot refuse work to stay on unemployment benefits. I think Ohio recently launched a sort of employee fraud reporting hotline. Pennsylvania has a link on Labor and Industries website where if an employer makes an offer for someone to return to work from layoff or recall from layoff, and they refuse because they'd rather stay on unemployment, they're making more, they just don't feel like coming in, the employer needs to report that within 7 days. Now, I don't think that applies to employees who say, I'm uncomfortable, I'm concerned, and it certainly doesn't apply to someone who says, I have an underlying health condition, I can't return to work because I'm at a higher risk. Those are not instances where you would want to report someone for refusing work to stay on unemployment or otherwise refusing a valid offer of work. And we also know that there was some additional PPP, Paycheck Protection Program guidance issued this week. Employers can still receive loan forgiveness if they make a valid offer in writing to an employee to recall them from layoff and that employee refuses. That should not penalize the employer on their loan forgiveness. The facts and the updates keep coming, so stay on top of it. Recently, the DOL issued facts about health plan coverage of COVID-19 testing and related services. And on April 20th, there were additional facts that came out. How do you calculate the regular pay during the paid leave for part-time employees and employees with regular hours? So it's a fast and furious pace. One of the things that we'll talk about too is what resources can employers use? We know the DOH has issued multiple facts, frequently asked questions, additional orders, updates. It's hard to stay on top of things. So make sure that you have some good resources that you can rely on. Speaking of the Department of Health orders, April 15th, an important Department of Health order came out. It applied to businesses who are authorized to maintain in-person operations other than healthcare providers. And please note that if your business is more stringently regulated, let's say by the FDA, if you're a food manufacturer or healthcare providers, if you're more stringently regulated, airports, you have to comply with the more stringent regulations. But the DOH order basically established safeguards and protocols for those businesses who are maintaining in-person operations. And some of the most important things we'll talk about. That is, if your business or your place of employment has been exposed to a probable or confirmed case, you've got to have these things in place, and you need to have them in place now as we prepare to reopen for those of us who are not physically conducting operations at this time. Special cleaning protocols. We know that the DOH has required everyone to wait 24 hours before you can even clean an area where the person has been exposed. If you have separate buildings, you only need to close the area of that building, not the whole campus, where an individual was exposed. But you need to keep people out of that area, isolate it, wait 24 hours, and ideally you have a contractor come in who is experienced and who has the capability to clean and sanitize. You also need to make sure that you notify anyone who has come into contact with an employee who is a probable or confirmed case of COVID, and you look back 48 hours. You have to have a temperature screening protocol in place once there is probable or confirmed case in the workplace, and you've got to notify those contacts of the probable or confirmed employee. You also have to provide and require masks for all employees. There are some exceptions if there's a medical condition that would prevent them from wearing a mask, or if it's not safe, if they're operating equipment, or if it's not safe to perform a task, if they would be wearing the mask. We also know that in your private office, you don't have to wear the mask, but if someone comes in to talk with you, you have to put the mask on and they have to have the mask on. You need to provide access to hand washing stations, sinks, soap, and sanitizers. You need to make sure that there's sufficient space for breaks in break areas and common areas with safe distancing. You got to stagger stop and start and break times whenever possible. And that includes also too, if you do have to implement temperature screening, or you decide that you want to implement temperature screening, you can't have, crowds of employees hanging out outside. It's got to be socially distanced. You want to try to figure out the best way to stagger those break times so that you don't have more than ideally 10 or up to 25 people congregating outside. Again, they do need to practice social distancing. If you are public facing, you want to have shields and barriers at your checkout areas. You want to prohibit non-essential visitors, and you need to designate service time for the elderly. Again, this is all for public facing employers who are conducting operations now. Once law firms and other businesses that are closed reopen, if you serve the public, then you need to comply with all of these requirements as well. In addition, 50% occupancy limit. We see that in most of the grocery stores currently. This will apply to you if you're public facing and you're conducting physical operations. In addition, you have to make sure that you have sufficient staff to control and enforce. Who is going to be enforcing these mitigation policies? And you have to communicate these requirements, the CDC criteria, the flexible use of time off, and we'll talk about that a little bit more. So, to mask or not to mask? If you're in your vehicle by yourself driving, you don't have to mask. If you're in your office, you don't have to mask. We had talked about impeding vision or otherwise create an unsafe condition, or if you have a medical condition or complications. And thankfully, you're allowed to take it off while you're eating or drinking. But basically, your mask is your best friend these days, and employers must require that employees have them. So employers must provide them and that employees wear them. And clients for law firms coming in need to wear masks, and other individuals coming into the firm need to wear masks unless and until the DOH changes that recommendation. Now, what is a probable case? We talked about those protocols to handle probable or confirmed cases. So a probable case is symptoms plus exposure to a high-risk situation. So someone said, their employee's spouse works in an emergency room or works in the COVID unit. Is that a probable case? With symptoms, that is a probable case. Without symptoms, that is not a probable case. But of course, you want to take every appropriate precaution to limit that individual's exposure in the workplace if they can't work remotely. When are temperature screens necessary? DOH is encouraging everyone to do temperature screens, but it's hard to find thermometers. It's really hard to find touchless scan thermometers. The DOH has established a business-to-business resource page where you can try to get them. But if there is a probable or confirmed case of COVID in the workplace, employers must temperature screen all employees coming into the building for 14 days after exposure. And a fever is defined as 100.4. No one gets in with a fever under the DOH orders. Who's going to do the screening? Self-screening is not permitted, unfortunately. Employers can outsource. That might be tough right now. What should you do? You should reach out to whoever your your workers' comp healthcare provider is. If you use a Concentra, if you use WellSpan. In addition, I note that WellSpan has some great resources out there, especially if employees don't have a primary care physician. Employers want to be reaching out to their workers' comp providers to say, what can you do to help us in a situation where we have a probable or exposed case? What can we do in the interim to connect employees with healthcare? How can you help us work to mitigate exposure, to implement temperature screening if appropriate, and to take other precautions? So consider them a valuable resource and reach out to them, ideally before you open, so you have some plans in place before there might be a probable case. The person doing the screening, if the employer is not outsourcing it, should not be someone from a vulnerable patient population. That means they shouldn't have an underlying pre-existing medical condition, and they ideally want to be less than 50 years of age. They don't need to be a nurse, but they should have basic qualifications. I don't know if you have anybody like that on your workforce, but perhaps they've been CPR trained, or they might have some basic medical background or survival skills. That might be someone who's appropriate to do the screening if you find yourself in a situation where you must temperature screen. And I guess the other thing to consider is, if you say, we don't have the resources, we couldn't implement temperature screening, what do we do if there's a probable case? We know that the DOH requires temperature screening for 14 days after exposure. So if you close the operations, have everyone work remotely for 14 days, then you could reopen without temperature screening after 14 days if you aren't able to implement the temperature screening. How do we handle the temperature screening? Ideally, we've got a policy in place for that uniform enforcement. Like, this is when we do it, this is how we do it, here's the mandatory entrance point, so we don't have people going in the side door where they aren't getting screened. Are we going to give people assigned start times every 5 minutes apart so that they don't stand in line with 20 people? Socially distanced must be followed at all times. And in Pennsylvania, at least, and our surrounding states, the time spent in line to be temperature screened is not compensable. But if you're in California, I think it is. So, new guidance came out on May 5th. This guidance applies to everyone that's going to reopen when we move from red to yellow. We know that there's about 24 counties that will be moving to the yellow zone tomorrow. And basically what this guidance says is that all that previous guidance that applied to life-sustaining businesses who were operating during the governor's closure order, everyone who's open now must follow all of these preventative measures, mitigation measures, in the yellow zone. And you've got to keep that in place basically until your county goes from yellow to green. Keep in mind too that going from red to yellow does not mean that people don't have to telework and that you can require them to come in. The governor's order makes it clear that telework must continue wherever feasible, and it's really important to prevent the spread of COVID-19. So if you're doing telework now, that should largely continue the same. You can consider having individuals come in on a staggered day. Someone comes in maybe Monday to pick up things, print things out, take care of things in the office, and then the other person can come in Tuesday, or if you need to, someone comes in the morning, they leave, someone comes in the afternoon. But again, it's all about reducing exposure and really working hard to prevent any outbreaks or exposure, especially in your workplace. The guidance now says that you need a pandemic safety officer, and that person's going to be in charge of implementing those safety protocols and mitigation protocols. Employers have to also post this COVID-19 safety procedures for businesses flyer. It's on the DOH resources for COVID-19 webpage, but I couldn't find it. The first time I clicked on it on May 5th, the page wasn't up. Now the page is up, but again, I couldn't find it. Hopefully it'll be coming out soon, and we'll all be able to post it. Tomorrow is the date that you have to post it for those employers going from red to yellow. So we hope that it is available tomorrow. And there are specific requirements for that COVID-19 safety procedures flyer. You have to print, sign, and post, and it has to be signed by like the business owner or the person in charge of that location or that site. And it has to be posted where employees can see it. And if you're public facing, it has to be posted where customers can see it too. And it's basically your promise that you are implementing and following the guidance. So what are the takeaways? Things are changing daily. You've got to follow CDC guidance. You've got to follow Department of Health guidance. You've got to be flexible, creative, innovative, and build on what we currently know and expect changes to be issued. And here's the other thing to keep in mind. At any time, be ready to go back to life in the red zone, because we know that the spread might increase once the restrictions are loosened up. We understand there might be a second round of this in the fall. So don't forget all of those things that you learned and implemented while we have been closed. Keep in mind what you can do to maybe make it a better experience if there are additional closures or if we see a second wave in the fall. There was an amendment to House Bill 2412 that would allow law firms as well as real estate firms to reopen immediately. Real estate is open immediately. This bill passed the House. It hasn't gone to the Senate yet, so it's just kind of sitting there. But we know that the governor's guidance issued on May 5th says every business that is not specifically prohibited from opening in the yellow zone is permitted to reopen when your county goes from red to yellow. So that means law firms can reopen when your county moves from red to yellow. But things like hair salons, theaters, entertainment venues, restaurants, they cannot reopen. Restaurants still have to provide curbside and takeout, unfortunately. What should you be doing? Well, we know some of you might be ready to open tomorrow. You've got to make sure that you have plans in place. What are you going to do when you get the yellow light or the green light? Prepare your workplace and prepare your workforce. You have to educate your employees on what to expect coming back to work. If you're teleworking, you remain teleworking. If you need to come in, you can come in during this designated time. Sanitize, wash your hands, wipe down the doors. Take into account planning, preparation, and policies. You want to have a policy. Social distancing. What does your break room look like with social distancing? What are your bathrooms? How can they accommodate? Is it going to be just one person at a time in the ladies' room, one person at a time in the men's room? What's going to happen if there's exposure in the workplace? Who should somebody notify? Who's responsible for shutting down the building? When can employees safely come back to work? And make sure that you keep your confidentiality. You should not be saying, who was exposed in the workplace, but you certainly do need to communicate to employees who were close contacts. You may have been exposed to someone who is a probable case or confirmed case of COVID. So keep in mind, employers are required to publish that and inform employees about the guidance for employee safety, and do all that stuff that we've been hearing from the beginning. Wash your hands, avoid mass transit, cover your mouth, don't touch your face, which is really hard. Don't forget masks for employees. If you're going to be opening up to clients, they need masks. Are they going to bring their own pen? How can you do contactless paper exchanges and contactless delivery exchanges? Borrow from Taco Bell and the other restaurants that are handing out trays to put things on to let the individual pick them up without touching. What do your paid time off policies suggest? Do you have a liberal leave policy? How are you going to work with employees who say, I'm afraid to come back to work, I'm a high risk, I need to telework more, or I can't come in, I'm too afraid, I have a high risk family member and I can't risk them being exposed to COVID. How are you going to handle that? Keep in mind too that you've got that emergency paid leave and the expanded FMLA leave in place as well. You should have a policy for those paid leaves, and you should have a request form, because we know that the IRS and the DOL require specific documentation for you to get your tax credits. Again, think about scheduling. Can we do altered shifts? Can we have people come in at different times? Who needs to use public transportation? Who's at high risk? Who might have childcare issues? What can we do to reduce our density and implement social distancing? Work from home. We know that the governor's guidance says telework must continue wherever feasible. Think about maybe a Saturday workday as an option, so that you can keep the number of people in the building limited. Assess your law firm or your other business activities for those employers joining us who aren't law firms. Restrict in-person client meetings. Restrict visitors as much as possible. Restrict those for lawyers. Obviously, right now you can't go to correctional facilities or detainment centers. You can't go to nursing homes to update clients' wills. How can you work around that? What can you do to provide those services that are necessary without increased exposure? You want to prohibit work-related travel to areas where COVID remains more widespread too. You don't want your employees traveling to New York City or other areas where COVID is, and that might even be other counties too. Lancaster is at a much higher rate, unfortunately, than York is. So you don't want people traveling for work-related reasons to those areas where COVID's more widespread. You can also prohibit employees from coming into work if they choose to go visit family members in areas that are more infectious, so they can be required to work from home. And if they can't telework, then they could get unemployment for those 14 days, but consider prohibiting them from coming into the office if they have been in a high-risk area. You also want to prohibit gatherings or meetings of more than 10 people for right now. Continue to use Zoom and other video conferencing or calls. And again, keep in mind, when do you think it would be appropriate to allow essential visitors? And how are you going to expand access as circumstances change? Can you shift your cubicles around? Can you rearrange workstations? Can you put in partitions? What kinds of things can you do if your workstations aren't separated by at least 6 feet? And how can you restrict the break rooms, meeting rooms, law libraries, traffic flow? Maybe there's just one way in the break room, so try to limit that. If you have 2 ways in and out, make one the designated entrance and one the designated exit. What are you going to do about elevators? Maybe a spot on the floor. If your elevator is big enough that can allow 2 people, one person can stand in one corner and the other in the opposite corner, or it's just one person at a time in the elevator if necessary. What other ways can you implement social distancing in the office? That's critical. And how can you reduce the frequency of contact? Printers, copiers, telephones, have those sanitizing wipes available at every spot where there's significant high touch. Again, wiping things down, cleaning activities, disinfecting, that's all really important. And most of us may be doing it ourselves right now. Keep in mind, we do have to communicate these workplace safety procedures in addition to posting that COVID-19 flyer. And there's some really great resources out there. Cushman and Wakefield, the 6 Feet Office, it's a great resource. So consider taking a look at that. Collaboration, sharing with your colleagues, sharing with others in the community. Hey, what are you guys doing to address the situation? How do we as a small employer or a small business, implement these requirements? Action steps, written directives, safety protocols, develop a response protocol, notice of rights, teleworking policies. Keep that in mind too. This is not going to be business as usual when we go back. Teleworking is here to stay. How are you going to implement that? When is it okay to have everybody back? Who's eligible for teleworking in a pandemic and not in a pandemic? Take a look at your attendance policies. Does that need to be updated? Make sure you have the FFCRA policies in form. Don't forget your documentation to support your loans as well as tax credits. Make sure you have your employee assistance program information available if it's applicable, and keep an eye on those regulatory updates. Now, as we return to the workplace, what are some things that we need to look out for? We know that the Emergency Paid Sick Leave Act and the Emergency Family Medical Leave will be treated as violations under the FLSA. So if you don't pay what people are entitled to under those leaves, you're looking at a violation of the Fair Labor Standards Act, which also provides additional damages and attorney's fees. And under Pennsylvania law, failure to pay wages can also be brought under the wage payment and collection law, which also provides for liquidated damages and attorney's fees. Keep in mind, this goes through the end of the year. So it's not just a one and done once life sort of returns to semi-normal. What are you doing right now for those employees who are teleworking? You've got to keep accurate records and documentation. And DOL has made it clear, like right now during the COVID-19 pandemic, they're not going to hold employers as accountable as they would normally. If you have someone who's teleworking and the employer didn't know and doesn't know they were working, employers aren't going to get dinged for that, but you still need to make sure your employees are keeping accurate records. Working remotely, emails from employees at all hours of the night, or if they're not salaried, this is really important that they know how to track their time and they are tracking their time accurately. The ADA, that applies to you if you have 15 or more employees. If you're a smaller employer, if you have 4 or more employees, the Pennsylvania Human Relations Act applies to you. And this means that individuals with a disability are protected and they are generally entitled to accommodation as long as the accommodation is reasonable. But it's not just individuals with disability, it's a perceived disability. And just yesterday I saw there was a lawsuit that was brought, I'm not sure if it was brought against Amazon, I think so, by an individual for perceived disability under COVID. They thought they had COVID and I can't remember the exact circumstances, but eventually they were discharged or there was some adverse action and they sued saying that you perceived me as having a disability and that's why you treated me differently. We talked about dealing with employees who are afraid to come back to work. If they are concerned about coming back to work because they have an underlying health condition and that is a disability, or maybe protected, then they should be accommodated with telework or leave. And keep in mind, they may be entitled to FMLA leave for their own serious health condition if you are an employer with 50 or more employees. So if they're teleworking now, they should continue to telework unless and until the risk goes away, because you've allowed them to work now. And maybe once your business returns to normal, you might be able to say, look, your productivity was low during telework, which we could accommodate while we were in COVID, but now that we're returning to normal, we need your productivity to be higher. So here's what we're going to do. We're going to ask you to come into the office 2 days a week. You'll be in a separate office. You won't be exposed to others. You can use this separate bathroom. That may not be possible, but think about ways that you could reduce their concern and their risk so that you could get them back to work while mitigating any exposure and still considering what is an accommodation if they have an underlying condition. You have to engage in the interactive process with individuals who are requesting time off or leave or telework due to an underlying condition that's protected. And that can be just what I said. Let's talk about how we can work you back in. Let's phase you back in. Here's what we can do. Here's how we can prevent your exposure. I think being reasonable and being equitable will go a long way in getting your employees back to work, while also protecting the employer from additional claims. But you do have to keep in mind the interactive process and the accommodation process under the ADA or the Pennsylvania Human Relations Act for individuals who have a disability and are protected. FMLA leave, that doesn't go away. If someone has taken paid sick leave for their COVID-19 related reasons, they might be eligible for FMLA for the remaining 10 weeks. Employers have to give appropriate notice and rights and responsibilities when anyone has a condition that appears to be FMLA qualifying. And again, that's up to 12 weeks for the employee's own serious health condition. So please don't forget about that. Again, once FMLA leave expires, you need to analyze their request for additional leave or accommodations under the Americans with Disabilities Act. So it's not a 12 weeks and done. They may be entitled to additional leave. OSHA. Initially, OSHA indicated that any COVID-19 illness in the workplace was a reportable event. On April 13th, they came out with some new guidance. Now there's enforcement discretion for most industries, not healthcare, but most industries, including law firms, have discretion to report whether or not it is a work-related. And there is an exception for those industries who have that discretion. You must report COVID-19 related illnesses as a work-related illness if you have objective evidence. So if you've implemented temperature screening because there's a probable or confirmed case, then you need to report that as a COVID-19 illness under OSHA. Keep in mind too, return to work issues, discrimination, retaliation. How are you going to return individuals to work? What's the job classification that comes back first? If you don't need everyone in that classification, who are you selecting in your workforce to return to work? Employers can't discriminate when we determine who should come back. You can't say, gosh, you know, according to the CDC guidance, individuals over 50 are more susceptible, or individuals over 50 shouldn't do temperature screening. So we're going to keep everyone out of the workplace if they're 50 years or older. You want to return people to work based on their skills, qualifications, the business needs, while keeping in mind if they have an underlying condition, they may be entitled to additional accommodation, telework time outside of the building, in order to accommodate their underlying health condition. Consider your OSHA workforce recommendations, the CDC and DOH guidance in COVID-19 screening. If you can, perhaps you want to implement some proactive screening for all employees. You can also do employee self-screening if you're not dealing with a probable or confirmed case in the workplace. So you could have a policy that says, no, until the pandemic is over or until further notice, employees must self-screen every morning before they physically enter the workplace. And that means you take your temperature. If you have a fever, you're not to come into work, and you contact HR or the appropriate person. If you don't have a thermometer, or if your thermometer doesn't work anymore, then the employee can, you know, self-screen to say, I don't feel like I have a fever, I don't have a cough, I don't have COVID symptoms, and so then I'm safe to come into work. But do plan ahead and return employees in a systematic and non-discriminatory manner, keeping in mind how you're going to deal with employees who are just concerned or afraid to come back versus employees who have an underlying condition and are entitled to additional accommodation because they may not be required to come back right away. Other areas of risk, employers have to provide masks. And if you are a healthcare provider, obviously you have to do a lot more than that. But if employees are complaining about issues with lack of PPE, or they're complaining that you're not implementing social distancing, or you haven't told them what mitigation measures are in place, or you're not cleaning things, this may be a protected activity under the National Labor Relations Act. And employees who are engaging in protected activity, talking about the terms and conditions of the workplace, you can't discipline them or terminate them. That will be considered a violation, will be considered an unfair labor practice. So keep those risks in mind as well, because you don't want to be taking that adverse action against individuals who have concerns about the workplace. So I wanted to make sure that we had some time for questions. And Victoria, if you want to see if we've got anything in the chat.
If an employee is asked to self-quarantine and they do not get a doctor's guidance, are they still eligible to be paid the employer's sick leave? That's part one.
That's a good question. So if the employer instructs them to self-quarantine, let's say they went to a funeral in New York or Manhattan or somewhere where there's a high incidence of exposure, and the employer says, you need to self-quarantine for 14 days. We can't have you in the workplace. We've been advising employers to provide paid sick leave to the employee because the employer has imposed a quarantine order. But to back that up, we also recommend that the employer contacts their workers' comp provider or a healthcare provider that they work with regularly and get a written recommendation or confirmation from that healthcare provider that yes, employees who visit high-risk areas or travel to high-risk areas should quarantine for 14 days. We think that's enough to support the paid sick leave and to get those tax credits for the employer. And if for some reason that employee doesn't get the paid sick leave, they will still be eligible for unemployment at this time during the COVID pandemic.
Are employees eligible for the $600 supplement if they are receiving partial unemployment comp benefits?
I believe so. I believe they're entitled to the entire $600, even if they're only getting partial benefits. And today, the Pandemic Assistance Unemployment link opened up on LNI. So previously, employees were only able, not employees, self-employed, independent contractors, gig workers were able to just put their information into the website. Today, it goes live so that people can actually apply for benefits. We'll see how well that works.
Another question, does an underlying condition of an employee include a family member with an underlying condition and or a family member in a at-risk class?
So no, under the ADA or the Pennsylvania Human Relations Act, the disability has to be that individual's own condition, their own medical condition that qualifies as a disability. If someone says, I'm concerned about coming to work because my family member is high risk, my family member has asthma, my family member has diabetes, they're not entitled to accommodation under the ADA. However, in the pandemic, it's important for employers to try to be as flexible as they can, to understand that employee's concern and to say, all right, you can continue to telework for this amount of time, or if that individual can't telework, is it possible for them to have an additional 2 weeks of leave? They can get unemployment. Oh, and employers should not be charged for these benefits that are being paid to employees for COVID-related reasons. So employers should make sure that you look out for your request for relief from charges forms, but LNI has made it clear you're not getting charged for these benefits that are paid to employees for COVID reasons. Going back to our question, the individual just says, I'm just not comfortable. I can't expose my son, my husband, my spouse, whatever. My grandmother lives with us. Talk to them about ways that they can reduce the risk at home and that ways that they can reduce the risk coming into the workplace. Phase in reduced physical work for them if possible. Make sure that you give them the EAP guidance. Connect them with your workers' comp or other healthcare community resources if they don't have a primary care physician, that they could then talk to their doctor or healthcare provider about how they could be comfortable coming back to work. But we really don't want to see employers terminating employees or saying, well, we consider this a resignation because you're refusing to come to work right now. That might change when everybody's in the green and if we don't see a recurrence. But right now, what we always try to do is to look ahead and say, how would this look if someone sued for wrongful termination? And again, that's not going to be an ADA claim because they don't have a protected condition. But who knows? They could say, I got anxiety because I was so worried that you wouldn't let me stay home and you forced me to come back. I had anxiety, so I am protected. Keep in mind, like, how would this look in 6 months before the EEOC or, how would this look before a judge? Encourage employers to be flexible, to be reasonable, and to try to be as fair as you can while maintaining your operations and taking into account the circumstances of the individual.
And multiple people have mentioned to me the fear of having workers' comp claims when people come back to work and they make an accusation of being exposed at work. Can you talk a little bit about that?
Sure. I think that it's going to be a little difficult to prove that workplace exposure occurred for that individual unless you have a confirmed case that was spread to employees in the workplace. That's why it's really important to make sure employees know if they feel sick, if they have a fever, they are not to come to work so that you can prevent that from happening. But if someone comes to work and they have a COVID diagnosis, they're going to have to prove they were exposed in the workplace. And that's a more difficult burden for a workers' comp claimant to prove. So I don't see that as being successful except in the healthcare settings, maybe our prison settings and the nursing home and the higher risk settings. For most of us, I don't see that being successful. Now, workers' comp will pay for testing, but we also know that there is no charge for COVID testing. And there are community resources available too that employees can get testing, and they are not going to be charged for them. There's a coupon code out there to get testing without charge. But as far as workers' comp is concerned, I think as long as the employers are following those mitigation policies and promptly reacting when there is a probable case in the workplace, you should generally not see too many workers' comp claims.
I want to follow up on one thing that you mentioned about the preventative measures that you can put in place now related to temperature screening. So can you elaborate on that? Would it be acceptable to have employees, as they come back to work, take their own temperature and complete a log that says this date, this time, this temperature?
Well, I think it's totally acceptable to implement self-screening now. That does not apply when you have a probable or confirmed case. Just keep that in mind. If you have a probable or a confirmed case, employers are not permitted to self-screen. The employer must screen or must outsource temperature screening for 14 days. That being said, as a strictly preventative measure, you can have employees self-screen, but you as the employer should not be writing down their temperature. That's medical information. Self-screening is medical information, which employers would normally not be able to do because it's a medical examination under the ADA. However, because we're in a pandemic, the direct threat to the safety and health of that employee and others is so great that employers are permitted to do limited medical examinations in the form of temperature screening. So if you're going to have self-screening just as a preventative measure, have that employee self-screen at home. And what we typically do is, if employers just don't have the capacity or don't want to deal with the administrative burden of having the employee complete a form or send a text or shoot an email that says, I self-screened, I do not have a fever. Again, we do not want their temperature. We just want them to confirm they don't have a fever. The policy can say merely by coming to work, the employee certifies that they have self-screened and they do not have a fever. But keep in mind, you will have some employees who don't have a thermometer. They never had one, or it broke and they can't get a hold of one. So there needs to be an alternative, and that would be screening for symptoms. And they also certify that they have not been exposed to a probable or COVID confirmed individual in the past 48 hours.
Okay, and here's another medical question. Is a temperature of 100 degrees good cause to ask someone to stay home versus 100.4?
So the CDC defines a fever as 100.4. Employers can be more cautious and say, look, anything 100 and over, because we just don't know how accurate your thermometer is. Anything over 100 or over, you're home. I think that's totally reasonable right now.
Well, that's all the questions that we have. Everyone, please stay on. I'm going to put the poll up. I want to thank you, Anne. And if you all would complete the evaluation, that would be greatly appreciated.
Great,
So
thank
it's
you.
coming up now.
Everyone stay safe, and we will email the PowerPoint slides out to everyone after the presentation is over.